We have one case this afternoon, Cynthia Renee Syverson against William Sasser Jones. Is the appellant ready to proceed?
Yes.
Please.
May it please the court, Beth Terry, I represent the appellant Ms. Cynthia Syverson, formerly known as Ms. Cynthia Jones, and I would like to reserve 3 minutes for rebuttal. This is the second appeal regarding the interpretation of the premarital agreement between the parties in the case. The first appeal, this court found in favor of Ms. Syverson and sent the matter back to the trial court with specific instructions on dividing certain proceeds of her condominium pursuant to the strict language of the premarital agreement. When we were here in the first oral argument, Judge Hawks at that time commented that the premarital agreement was drafted by the former husband. It did not disadvantage him, and that the former husband was basically not wanting to live up to the agreement.
But of course you understand that comments by one of the members of the panel at oral argument don't carry any weight.
I understand, Your Honor. And I was prefacing that comment with the fact that I submit that the same thing is happening here again, that the former husband is displeased with the prior ruling, as he has rehashed throughout his brief in this matter on different issues, and showing that displeasement through his motion to vacate the deed on the property in question here, the Ivy Hollow property, merely to show his displeasure and harass the former wife, because this, as the evidence shows, this property has no value and actually a negative value. And the former husband basically testified he had no idea what he wanted to do with the property, and just basically brought this action to show his displeasure.
And of course, family lawyers would be out of business if it weren't for their clients wanting to do things out of spite, wouldn't they? I mean, gosh, I remember enough instances of super dumb things done by one spouse or another. One that comes to mind was a case where the husband broke all of the wife's glass unicorn collection simply to teach her a lesson, and he said, "I'm happy to pay whatever they're worth."
Yes, Your Honor, I understand, and I think that probably does provide quite a percentage to family lawyers in their cases. But in this case,
As you indicated, this was appealed here once before, and in the opinion reversing and remanding, that panel, the court, said we reverse and remand, and with directions that, if applicable, there be a recalculation of equitable distribution. Is that what happened on remands?
Your Honor, from the first opinion, the court did state that, but that was in reference to where they were specifically targeting 2 issues that were going to be reversed and remanded. One was to do a division of the condo proceeds, which dealt with the interpretation of the prenuptial provision. And then there was another issue regarding credit for capital improvements on the marital home and certain other credits to the former husband. And that is, in that portion about the credits to the former husband, that is where they stated that in doing that and looking at those credits, remove those credits and, if needed, recalculate the equitable distribution. So I would submit that that was just into calculation of what the proceeds from the marital home and how that needed to be distributed and recalculated.
But whenever you do anything on appeal that affects the equitable distribution that took place in the trial court, don't you have to, of necessity, go back or direct the trial court to go back and reconsider the whole plan of distribution in light of what's been done on appeal?
I understand that that is the former husband's argument, all of the cases that have been cited by the former husband in regards that the court is free on remand to reconsider monetary things or equitable distribution if it's being reversed and remanded. But in every case that was cited, there were specific directions from this court or other appellate courts that you can look at the overall equitable distribution and revisit it if
And you're
it's necessary.
saying this language in the first opinion, or in the opinion on the first appeal, doesn't say that?
The way that I read it, I say that it does not, Your Honor.
What could it possibly mean for this court to say that the trial court, if applicable, can recalculate equitable distribution isn't intended to give that discretion to the trial court?
Your Honor, as I stated before, it is all composed into that one area of taking credits back that were given to the former husband on the marital home issue and removing those credits, and if those credits, recalculating what the amount of monies were due each party from the marital home. I would submit that it was just tied to that one specific issue, and as I stated, the other cases...
So you read the language as saying he was over-credited, and in order to do equity on remand, it might be necessary to order a cash payment by him to her.
Yes, Your Honor. Yes. And I do not read it in line with the other cases cited by the former husband, where there was specific language by the appellate court saying, since we are going back to revisit the overall scheme of equitable distribution or the other monetary awards.
And in any event, that's not what happened here on remand, is it? There was a motion to vacate and set aside the deed.
Correct.
Tell us about that.
Your Honor, the former husband filed a motion to vacate and set aside deed in the original judgment. The trial court ordered that the former husband would not have an interest in the Ivy Hollow property, which is the subject of this appeal.
As part of the equitable distribution.
Yes, Your Honor, in dividing up the properties, yes. And I would submit, as we stated down below, in response to the motion to vacate, that the trial court, in its oral pronouncements of its ruling, flatly denied former husband any interest in the Ivy Hollow property. Former husband and the partial final judgment tried to condition the fact that former husband was to receive all of the condo proceeds, and that's why the deed to this property should be set aside and Mr. Jones should have a portion of this property. However, if you read closely the partial final judgment, it states that upon Mr. Jones receiving his portion of the condo proceeds and a portion of the marital home proceeds, he will release the deed to Ms. Syverson, where she would have the whole property. He did receive proceeds from the condo. He did receive proceeds from the marital home. So he did receive what was properly under the law and the proper interpretation of the premarital agreement drafted by him, the proceeds that caused him that he should provide this home solely to the former wife.
All right, but a portion of those monies were ordered, given to her by the appeals court on the initial appeal.
Yes, Your Honor. Because the premarital agreement that was drafted by the former husband specifically mentioned the condo proceeds and that it would be a joint property and it would be deemed marital and evenly divided.
Both of you say that the standard of review for the issues you've raised is de novo because the trial court denied the motion to dismiss. I'm going to suggest to you the proper standard of review might well be abuse of discretion because the reason, according to the trial court, that he denied, and this was Judge Wiggins did the divorce and the thing on remand, didn't he?
Yes, Your Honor.
The reason Judge Wiggins gave for denying the motion to dismiss was that he would have never distributed the property the way he did as part of the scheme of equitable distribution, but for the way he distributed everything. And if part of it was going to fail, he wouldn't have given the other part where he did. And if his basis for denying the motion to dismiss was that it was no longer equitable to allow that deed to stand, I wonder why the standard of review wouldn't be abuse of discretion.
Your Honor, I think there is abuse of discretion standard in certain portions of the former wife's argument and the de novo standard when you're looking at the premarital agreement. We submit that this issue regarding the Ivy Hollow property is an interpretation of the premarital agreement, and we assert that there are ambiguities and therefore the contract should be interpreted based on the rules of construction as any contract in this court would have de novo standard to review that.
All right, so your position on this appeal is that the prenuptial agreement governs?
Yes, Your Honor. And that premarital agreement has ambiguity.
Well, why don't you tell us about paragraph 20, what that says?
Your Honor, paragraph 20, as outlined in the briefs, state that any and all other provisions notwithstanding, that any property titled in joint names would be considered marital unless specifically designated non-marital.
Well, wasn't this property titled in both names?
Yes, Your Honor.
And was there any written designation of it as separate property?
There is no written designation as separate property or as marital property.
So then under the agreement, it should be divided.
Well, Your Honor, under the agreement, I think there is a patent ambiguity in the agreement. If paragraph 20 is read with the other portions of the premarital agreement, as anyone interpreting a contract should look at the whole and the purpose of the whole contract to interpret it, paragraph 37, which is entitled joint titling, states that the parties intend that there's going to be property held in joint names that are to remain separate properties, regardless of what the legal title says. And it goes into more specific language about whoever puts forth the monies to obtain those properties is going to remain that person's non-marital property or at least have a separate interest. Then it also goes into more language saying that, well, if you want to exempt that joint title property out of this provision, you have to do so in writing and say that it's marital, and therefore it will be subject to survivorship and joint equitable distribution.
And failing that, paragraph 20 controls.
I'm saying the two don't coincide with each other. There's the ambiguity there. One paragraph is saying that you need to, everything's going to be deemed non-marital even if it's jointly titled unless you specify in writing that it is marital. And then we have another paragraph, paragraph 20, that states if it's joint title, it's going to be deemed marital unless you specify that it's not. And it doesn't, in that paragraph, even designate whether it has to be in writing.
Well, doesn't paragraph 20 trump paragraph 37? Because it says, any and all provisions of this agreement notwithstanding. So it is contemplating that there may be some conflicts between paragraph 20 and another provision, but it's paragraph 20 says it doesn't matter what's up in this agreement. This paragraph 20 trumps, it wins, because any and all assets titled in writing in the names of the parties shall be deemed marital property unless otherwise stated.
Your Honor, I understand your point. I understand that's also a former husband's argument. Even taking that as the clear language, and that is so, based on how the parties acted under this agreement, there is a latent ambiguity between paragraph 20 and paragraph 37. The parties had other jointly titled properties, sale proceeds from premarital homes that came during the marriage. The sale occurred during the marriage. The checks were jointly titled in both parties. They acted different than what paragraph 20 is saying. They would...
That doesn't create a latent ambiguity in the contract. It just indicates that they chose not to follow it at some point.
Your Honor, under the law stated in the brief regarding the Barrington case, they stated in the contract that they had that the parties' conduct, that sometimes they would follow a certain portion of the clear language and at other times they did not, that conduct of the parties operating under the agreement created a latent ambiguity because it was an extrinsic fact that came about.
But if the language is clear and unambiguous, why would you look at anything that was extrinsic to the contract? How do you even get there?
Your Honor, I submit that it's not clear and unambiguous.
Gosh, the language in that paragraph of the prenuptial agreement is pretty standard language for contracts generally, not just for premarital agreements.
It's taken that paragraph and the whole purpose of the contract and all the other provisions stating differently. There were other provisions such as paragraph 18 that talk about commingling. If you commingle properties and commingle assets with non-marital with marital, that's specifically stated in there. Joint title alone is insufficient to show that there was an intent to be marital. I think there are ambiguities throughout all of the language in the premarital agreement. And according to the Barrington case, the way the parties behave under the contract is the extrinsic fact that can also make it a latent ambiguity that needs to be determined based on the whole purpose of this premarital agreement, which was to protect each party's individual assets, especially if they funded it with non-marital premarital loans.
No, but just basically to recap, the result of the first appeal was that the agreement was enforced as to the condo and the marital home, and not as to Ivy Hollow.
The appeal, and I'm sorry if I'm not understanding your question correctly, the appeal remanded back on just the two issues of the condo, because that was specifically outlined in the premarital agreement.
But the original agreement said I'm not enforcing, the original decree said I'm not enforcing the agreement as to the condo. I'm not enforcing the agreement as to the marital home. I'm not enforcing the agreement as to Ivy Hollow. And then on appeal, you persuaded the prior panel to enforce the agreement as to the first two properties, but not as to Ivy Hollow.
Right, Your Honor, the Ivy Hollow was not an issue.
Not an issue on the prior appeal.
It was not an issue.
You're almost 2 minutes over your entire time, but we will give you 3 minutes on rebuttal and add 5 minutes to Mr. Jacobson's time.
Thank you.
Thank you.
For the record, I'm Sam Jacobson of Jacksonville, appearing for the appellant William Jones. Before I begin my argument, I would like to make one thing clear. On rereading my answer brief after some months, I realized that my criticisms of Ms. Terry's positions had been stated with enough strength that they might have been interpreted as being personally critical of her. I want it to be known that's not the case. I like Ms. Terry. I think she's conscientious ethically lawyer in that respect. Going to the case at hand, I think that there are some number of things that are absolutely inarguable here. One is that the Ivy Hollow property was titled jointly during the marriage, title taken during the marriage in joint names. The other is that under paragraph 20, as the court has pointed out 2 or 3 times now, property titled jointly during the marriage was to be deemed marital property. And the introductory clause to paragraph 20 said that notwithstanding any other provisions of the prenuptial agreement. It's also an argument.
So if there were a conflict with paragraph 27, paragraph 37, paragraph 20 would go.
And there's not a conflict anyway, because what paragraph 37 is, it says that if parties take property jointly in joint names for convenience or asset protection or whatever, and state that, make that clear otherwise, then that property is governed separately. But in the absence of some kind of statement or indication that that property is not to be considered joint, it is joint property, plain and simple.
Or as the opposing counsel has said, she is relying on the prenuptial agreement. And so your answer to that is if so, then the Ivy Hollow property is merit.
Yes, sir. Yes, sir.
And yet what happened with your motion to vacate set aside deed is your client ended up with not just with half the property, but with the entire property.
No. Under the original judgment, he had voluntarily, by his offer and his invitation to Judge Wiggins, had made that property 100% Eli's. What happened on the motion, and gave a deed to do that. What happened is when we went back, he then said that deed had been predicated on the awards that had been made to him, and in return for those awards, he was willing to be, whether it's called generous or what, he was willing for her to have the entirety of the Ivy Hollow property. But when his awards were taken back, he then said the deed ought to be vacated and he ought to have half of the Ivy Hollow property, not full. And his position here is that the award that was made of the entirety of the Ivy Hollow property was conditioned on and reciprocal for the awards that were made to him, and consequently had become inequitable and ought to be set aside.
Now, do you agree with the representation that the property is underwater?
I don't know. I know that I would agree that Ms. Terry's client said the property is underwater. Whether it is or not, I don't know, and I don't know that it makes any difference. However rich or poor the property is, if it's partly Mr. Jones's, he's entitled to his part. Whether it's worth a lot, whether it's worth a little, whether it's not worth nothing.
And one would think that if there really, truly is a negative equity in the property, that former wife would be happy for him to take half of that negative equity from her.
Well,
maybe I'm missing something.
Well, it could be argued that since she lives there and would not want to have to get out, that it maybe is worth more to her than it is anybody else, or maybe it's worth more to her than its fair market value is. But he hasn't made any move to try to get her out. He just wants his half ownership of it. If it appreciates in value, he wants his half appreciation.
Sort of the glass unicorns all over.
Not entirely.
You've been doing this long enough to know exactly what I'm talking about.
I can tell you about some things worse than
I know
those.
you can.
In fact, I thought I had heard everything until a recent case that I won't try to tell you about, at least not publicly.
Just a quick bar, are you going to be carrying on the conversation?
It would be appropriate to a bar, I'm afraid. It's also inarguable that the entire contention, the entire area of contention in connection with the first appeal was that dealt with the awards that had been made to Mr. Jones. Mr. Jones said that Mrs. Jones had not complied with the prenuptial agreement because she hadn't put up the down payment for the Alhambra home that she was supposed to. And more than that, there had been no good faith marriage. She came home from the honeymoon and moved back into her old house and then lived with him, and that she consequently was not entitled to anything under the prenuptial agreement. The first panel said that the prenuptial agreement was going to be read strictly, and that it didn't make any difference whether there was a good faith marriage or not. If there was a marriage ceremony, that was it. It didn't make any difference whether she failed to pay out put up the down payment she agreed to put up. She was going to get half of the Alhambra house and half of his premarital condo, and we came back down for Judge Wiggins to carry out those directions, including the direction, and I'll be frank with you, the statement at the end, I think it was Judge Benton who pointed out that at the end of the opinion, it says for such recalculation, if any was maybe required for equitable distribution. I had forgotten that. I didn't cite that in my brief. Ms. Terry had said over and over again in her brief that there had been nothing like that, and I just assumed that was the case. But you are correct, Judge Benton. The opinion does say that. It does that which the appellant is saying so vigorously never happened.
But she explains it as relating only to the credits.
Arguably, since that's the paragraph that comes in, but there's nothing in the language itself that limits it to that. It makes sense that it would not be limited. It would be consistent with what commonly and normally happens when there's an adjustment of that.
I just don't know what could be ambiguous about the language that says, and if applicable, recalculation of equitable distribution. Equitable distribution is equitable distribution. It's the entire scheme.
That's our position as well.
Mr. Jacobson, to what extent did our panel even address the Ivy Hollow?
None. If Ivy Hollow was mentioned in passing, in a fleeting fashion in our brief, we pointed out as part of the statement of facts that the husband had given up his right to Ivy Hollow in return for the awards that were made to him. That was it. There was no other reference. It wasn't referred to in an argument, as I recall. We don't have a transcript of the argument, but it was never any part of any issue or argument that was made in the brief. There was no reason for it to have been mentioned in oral argument. Apart from that, it certainly was not even remotely mentioned in the court's opinion. So there was definitely no ruling. It was never explicitly or implicitly touched on in the court's opinion.
Just for your information, the oral argument is probably archived and available on the internet. But I have a question for you, and that is, why did you file a notice of cross appeal on the initial appeal?
I don't think I did. If I did, I don't remember it. Your question surprises me. I didn't think I did.
Well, in the opinion on the prior appeal does not list the former husband as a cross-appellant.
Right, it wasn't pursued. That's my understanding of the state of the record.
Frankly, Judge, I'd have to check the record. But it wasn't something that I was going to be cross-appealing, because the Ivy Hollow matter was something that we had volunteered. How was I going to be saying it was error for the judge to do what we had said it was okay with us for him to do, and suggested that he do? It wasn't until the opinion came down that we felt that we'd been wounded having this.
I mean, so you viewed the original judgment as a bargain that had been made between the parties?
As far as we were concerned, we didn't have to give up any claim to Ivy Hollow. We said if Mr. Jones got back his money that he put into the Alhambra house, that he had taken care of everything on that except for a small part of the binder that Mrs. Jones had put up. And in fact, after he moved out, which wasn't very long after she finally moved in, he continued making all the payments, everything that was paid for the Alhambra house for months and months until it got sold while she exclusively occupied it. All he wanted was his money back. And as far as the condominium was concerned, that was his premarital condominium. All he wanted was his condominium back. If that was done, he wasn't looking for anything more, and he was willing for her to have the entirety of Ivy Hollow, and agreed to it, suggested to Judge Wiggins, and the transcript couldn't be more clear about that. It was his idea, and it was a decent thing for him to do, that he should not wind up in his life. There is no question that the matter of Ivy Hollow was not touched upon, not even tangentially, in what the initial panel of the court did, which brings into play DOT versus Giuliano, which says that the law of the case which is the argument I understand Mrs. Jones and Syverson to be making most vigorously, that argument does not come into play. A matter has to be actually decided and specifically addressed and ruled upon before the law of the case comes into play to bar any kind of subsequent action consistent or inconsistent with the opinion that was in it. And that plainly is not the case here. Not only that, but going beyond that, there are exceptions to the law of the case. One of the exceptions, the prime exception, I shouldn't say the prime, there are two equal exceptions. One is that if there's been a change of facts, then the law of the case doctrine is not applicable to bar a contention. And here, there was clearly a huge change of $130,000 change of facts when Mr. Jones lost his 2 awards and was left without even his half interest in the Ivy Hollow property. That was a change of facts warranting re-examination and recalculation by Judge Wiggins. Beyond that, the second exception is that manifest injustice is going to be created by a rigid application of the law of the case. And if that's the case, then it is not to be done. Here, there...
Do you think that a change of facts exception is available here?
I think that there was a substantial change of facts when Mr. Jones lost the 2 awards he had fought for and won in the first review, or in the first trial. He was...
But the change of facts you're talking about is the decision of the original appeal.
Yes, sir. I'm saying you might be raising the question whether there had to be some change in the underlying facts, the facts underlying
I
the
believe
case.
that's what that exception is concerning.
Well, I haven't seen anything that says that, and there certainly was a big change in the landscape when Mr. Jones lost the 2 things that were most important to him and which had been a predicate for his giving up his half interest in the outcome. Moving on to res judicata, the Giuliano case, and there are a ton of cases dealing with Giuliano. I haven't tried to cite any of them, or a lot of these, a law review could be written on the theory of beware the lawyer in point case, because Giuliano is the controlling case in the decision here. And Giuliano expressly deals with the question of res judicata and says that res judicata only applies in the case of subsequent cases or request for determination. Does not apply to successive phases of one case.
Well, there can't be res judicata here because the former wife challenged the final judgment in the first appeal, and the courts granted her challenge and set it aside, so the judgment no longer exists.
And everybody was back before the trial court under the first panel ruling for a determination of fees, for a determination of how to implement what the first panel was ruling, and for the recalculation of equitable distribution of the first panel. So res judicata, we think, is not anywhere nearly within the picture. The next argument raised by the appellant is that Judge Wiggins misinterpreted the prenuptial agreement. We think that this is misapprehension of what Judge Wiggins did. Judge Wiggins didn't interpret the prenuptial agreement at all when he was ruling here, when he restored Mr. Jones's half of Ivy Hollow to him. What Judge Wiggins did is said that I took it away from him by his agreement because of the awards he's gotten. Now that he's lost his awards and he's withdrawn his agreement, I'm going to give it back to him, which is manifestly the fair and reasonable thing to do. That didn't involve any kind of interpretation of the prenuptial agreement.
He was simply trying to equitably distribute the property.
And he said so as expressly and explicitly. I'm sure you've read the order. There was just no equivocation whatever in his position.
Which is why I suggested that perhaps the proper standard of review is abuse of discretion.
Well, I agree that de novo is the proper standard of review as to the law of the case and res judicata points, because those seem to be limits of law. And then I think that as to the other, I agree that it's abuse of discretion. And certainly it was within the realm of his discretion to rule as he did on the facts of this case. With all respect to Ms. Terry, he cried out for some redress of what happened as a result of what had gone on previously.
So the trial court here relied on an opinion from the court, a wise opinion. But isn't that distinguishable?
It's distinguishable. It's a parsing of the Giuliano case. It's a case in which you dissented on a very fine point of interpretation of the Giuliano case, and it's not at all factual like the situation.
My memory is in that case that equitable distribution had actually been expressly challenged. I took a different look at it in a dissent, but I think that there wasn't much of a question that the parties had challenged the equitable distribution.
Well, what happened in that case is it dealt with a federal annuity, retirement annuity, and it was determined that the trial judge didn't have the right to do legally what he did, and he said that the case ought to go back for a recalculation. And two members of the panel felt that there should be a recalculation. You felt that there shouldn't be because you said that was dictum and that was post fact. And it was a fine point. It probably was a rarefied question of res judicata in the case. Don't put it as a bearing here. That's why even though the trial judge cited it, I didn't try to. There are also the points that have been raised about basic inequity of what the trial judge did. I probably have said as much as I need to say on that, especially with our contention that is a question of abuse of discretion. There's also the claim of special equity. I don't think I really need to add anything to what's in the brief. That seems to me not to be a matter of I don't want to presume, but it doesn't seem to me to be a matter of difficulty for the court. And also the argument that Judge Wiggins failed to reopen the evidence to let in the closing statement. We say that was manifestly a question of trial management, well within his discretion. It wouldn't have made any difference. It was just what they were wanting to reopen for was just cumulative. And then the clean hands argument. I don't want to use the term spurious, but nothing else comes to my mind.
All right, we'll just leave it there. Thank you, Mr. Jacobs.
Thank you.
And was I mistaken about the notice of cross appeal?
Your Honor, it was my understanding that there was a notice of cross appeal in the original, but if you were correct, it was never pursued, so it was never developed into any type of caption or anything. Your Honor, and the panel, excuse me, a couple points. As it was pointed out, premarital agreement is going to be used to interpret how the parties are dividing up their property, as was stated in the first appeal. It should also here. Even if this court does not agree with the former wife that there is no ambiguity whether patent or latent, their paragraphs 18 and paragraph 37 of the premarital agreement specifically state that there should be a separate ownership interests of any party that puts in non-marital funds to jointly titled property. Whether you commingle it, whether you've designated something in writing or didn't designate something, and it's clear, and the only evidence was that former wife, Ms. Syverson, put her premarital monies to purchase this home. She is the one that put the money into it. She's the one that has done the debt service. She's the one that has done the maintenance and provided all the funds for this. So the court should have...
But it factually didn't she take it all out?
She did not take it all out. If the motion to reopen, to put in the closing statement, it would have shown the exact dollar figure, that it was $58,000 approximately that she put down on the home. She took out, by her testimony that was in the trial, $45,000. So there's approximately a $13,000 separate ownership interest that should be in this property.
And she rented it for close to $2,000 a month for some period of time.
Yes, Your Honor, and by the only unrebutted testimony that rent did not cover the mortgage payment. There was no profit, there was no benefit that she was receiving. And I would also point out the premarital agreement has provisions, I think in paragraph 17, that state any income of the parties during the marriage, whether it comes from investments such as rental properties or whatnot, would be their non-marital property, and it would not affect to do what she would wish to do with. And therefore, she was putting more non-marital funds, I guess, from receiving the rents to cover that mortgage into this property.
Ms. Terry, let me ask you one last time, because you've talked about paragraphs 18 and 37 and the inconsistencies they create. How do you interpret the language in paragraph 20 that says, any and all provisions of this agreement notwithstanding?
Your Honor, I understand that language in that paragraph that states that no other provisions withstanding, this is what it's going to hold.
It's pretty clear and unambiguous, isn't it?
Even if it's clear and unambiguous, Your Honor, based on the law that we cite in our brief, the Barrington case, that the way the parties operated on other jointly titled assets under this agreement create a latent ambiguity. And even if we're not even going to address the ambiguity, and this panel finds that it's very clear that paragraph 20 holds, there are the other paragraphs of the premarital agreement, 18 and 37, state if you put non-marital funds, whoever party it is, into a piece of property, you will have a separate ownership interest in that, or a special equity, whichever terminology they were using in that paragraph. She had over $13,000 a separate interest in this property. But there was no other evidence but the testimony by former wife, the value of the house. The trial court stated in its pronouncement that there was no value in this property. So she has a separate ownership interest in more of the value.
That would be the takeaway point. No value in the property. Thank you, Ms. Terry.
Yes, thank you.
Court is in recess.